They're really good.
Yeah, we didn't know. Nobody told us.
Well, it's because
all rise. You may be seated. The court has received word from the jury. Even after further substantial deliberations, we are unable to reach a verdict on either count 1 or count 2. We have concluded our deliberations. You have considered this case for a considerable length of time and reported to the court that you are unable to reach a verdict. The court accepts this conclusion and finds that there is no probability of the jury agreeing. The jury has deliberated for more than 25 hours. You have previously indicated that you were unable to reach a unanimous verdict. You are again saying that after a night of sleep and 2 additional hours of deliberations, you are unable to reach a unanimous verdict. By reason of your inability to reach a verdict, I declare this case a mistrial. Nevertheless, I want to express my appreciation for your efforts. It is obvious that you have made a sincere and conscientious effort. So everyone is aware, what I'm about to read is straight out of Ohio Jury Instructions 429.13. After you are discharged, you may discuss your deliberations with others, but you are not required to do so. You must decide for yourself whether or not you will discuss such matters. In any event, you should be careful what you say. You should make no statement, verbal or in writing, unless you are sure that it is complete and correct. You should make no statement that you would not be willing to make under oath in the presence of the court, the other jurors, the litigants, and their respective counsel. If your statements are to the press, remember, your name and your statement may appear in print, in which event you should be doubly cautious to be sure that your statement is absolutely correct, in whole and in part, because the press will only use the part that the reporter considers sufficiently newsworthy or challenging. As jurors, you have served as public officers of the court. When you are discharged and I leave the bench, your services are completed, and you have all the rights to privacy of private citizens. It is the lawyer's duty to protect those rights, and your desire not to talk about this case if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence on you for the purpose of getting you to talk about this case. Now, what I'm about to tell you is not from the Ohio Jury Instructions. Your juror questionnaires were a matter that was raised by the media in this case. That issue is still being litigated. You have all expressed the desire to keep your identifying responses private. However, if you have decided that you would like to have contact with the media, you are free to do so. You may contact the media yourself, or if you would like to contact my bailiff with your information, he will provide your information to any media outlet who would like to talk to you. Likewise, any media outlet who would like to talk to a juror may leave their contact information with my bailiff to be provided to any interested juror. Remember, you are free, ladies and gentlemen of the jury, to reach out to the media on your own. You do not need to go through my bailiff to do so. I'm simply offering my bailiff's assistance if you choose to use it. On behalf of the court, the state of Ohio, and the defense in this case, we thank you for your service. I will return you to the jury room and ask that you will wait for me there. All rise for the jury. You may be seated. We will set a report date on this case on November 28th at 9 a.m. The bond will remain the same. The court is hereby lifting the gag order. The lawyers are free to speak to the press if they so choose. Is there anything on behalf of the state? Anything on behalf of the defense? Thank you, ladies and gentlemen, very much. Yep.
You got it. All right, folks, you're free to leave. So we have actually got somebody with her. Yes. And you,